Hi, I'm criminal defense attorney Aaron J. Boria, and today I'm going to be talking to you about drunk driving defense in Michigan. Drunk driving can happen to anybody. People come into my office and they tell me I'm not a criminal, this isn't me, and I believe that 100%. I've represented doctors, nurses, lawyers, even people in the criminal justice system that have been charged with drunk driving. Everyday people do get charged with this offense. There are many ways to challenge a drinking and driving offense. The first way I'm going to talk about is the stop. Police can't pull you over for anything. They have to have a legal reason to stop your vehicle. They can either observe you commit a civil infraction, like you're speeding or you roll through a stop sign, you don't use your blinker, or the police need to have reasonable suspicion that a crime is occurring. Sometimes this occurs when another driver on the road calls the police and reports your bad driving, concerned that you are a drinking driver. Or perhaps the officer observes slow driving combined with swerving and maybe some other poor but not illegal driving and believes that you're under the influence of alcohol and pulls you over. A police officer cannot pull you over for things that aren't illegal. If police officers pull you over and they don't have a civil infraction to point to, and they don't have reasonable suspicion, or they don't have enough, then your case is going to be dismissed because it's an illegal stop, and any evidence that they gain after that is going to be suppressed. The second way that we fight a drinking and driving offense is the arrest. Let's assume that you've been legally pulled over. Now the officer is going to start asking you questions. How much have you had to drink tonight? And they're going to ask you to get out of the vehicle and perform field sobriety tests. If you refuse all these tests and they have no evidence, or if you do the tests and you pass them and they arrest you anyway, they probably don't have probable cause. And at that point, the arrest is illegal. And again, any evidence they gain after that, which would be your blood alcohol level, needs to be suppressed. And then the case would be dismissed. The third major way that we fight a drinking and driving offense is by challenging the chemical test results. Blood is a different animal, and I'm not going to go into that because it is very detailed. However, with a breath test done at the station, there are certain things that are required. And as much as they want you to believe that these instruments are infallible, it's simply not true. And if the test is performed incorrectly, a judge may dismiss it. And if that happens, it'll be dismissed along with the rest of your case. The major challenge of going to trial, where you hold the prosecutor to their burden to meet all the elements of the crime beyond a reasonable doubt. And if the prosecutor can't meet that burden, the jury will find you not guilty. Now, many times, challenges to trial can be that the officer was lying, the officer was over-exaggerating, you weren't as drunk as you said. Maybe you had an issue with your stomach or something else that may have caused the blood alcohol level to read higher than it actually was. Maybe the test wasn't performed correctly, but the judge didn't dismiss it, but it was enough that a jury believes that there's reason to doubt the test, and they throw it out, and they find you not guilty. I'm Aaron Boria, and I defend everyday people accused of drinking and driving. Even if we can't get a dismissal on your case, or it doesn't look like a jury would find you not guilty, there's always a good chance that we can get you a reduction to keep you out of jail, keep your license, save you money, and make life better for you. If you've been accused of drinking and driving, give me a call, 734-453-7806, or shoot me an email at borialaw@gmail.com. I am happy to fight for you.